Welcome back to Custody Truth. Today, a courtroom battle over child custody takes a dramatic turn as two states fight for jurisdiction. Shocking allegations come to light, and a judge delivers a decision that changes everything. Stay with us until the end. You won't want to miss this verdict.
Ms. Buckner and Mr. Solomos finalized their divorce, I believe, in 2023. Within that divorce decree, the Ms. Solomos was given the right to establish the primary right or designate the primary residence of the child within Travis County and within Mashpee Town, Massachusetts, which is where she moved to and is currently residing. She has resided there continuously since then. The child has lived there. The child has not made any reasonable contact with Texas since then. I don't believe that there is any family besides Mr. Solomos in Texas, including Mr. Solomos's family, who resides, I believe, in California. It's our belief that this child has no meaningful contacts with the state of Texas. We also believe that it would be an inconvenient for him. Under 152.202A1, Texas loses jurisdiction if the child and one parent do not reside in Texas and have no significant contact with Texas, and there's no substantial evidence concerning the child's care in Texas. The child is established in school in Massachusetts. The child has family members in Massachusetts that they have a very good relationship with. Mr. Solomos has not seen the child in over 2 years at this point, I believe. And we believe that Massachusetts is the correct forum for any form of modification or further litigation on the issue of the child.
Okay. All right. Ms. Moore, would you like to address that?
Yes, Your Honor. So this court did finalize the divorce decree. It heard the case on May 6, 2024. The decree was not signed until September 13, 2024. Pursuant to the Texas Family Code 152.202, Texas retains jurisdiction until the court makes a decision that it no longer has jurisdiction. In the divorce decree, although it allows Ms. Solomos to designate geographical restriction in Travis County or in the Mashpee Town, Barnstable County in Massachusetts, she had listed her address as Austin, Texas, within the decree. There is no notice of address change on file where she's moved to Massachusetts. And then I also have case law to support Texas maintaining jurisdiction for this matter. In Cortez versus Cortez, which is the Texas Court of Appeals from December of 2021, it says that we construe pleadings in favor of the party invoking jurisdiction and consider relevant evidence when necessary to resolve the jurisdictional issue. Even if the child acquires a new home state, the state that made the initial child custody determination retains exclusive continuing jurisdiction so long as the general requisites of the substantial connection jurisdiction provisions are met. The state that made the initial child custody determination is the sole determinant of whether jurisdiction continues. In that same case, the child's actual presence in the state is not the only relevant consideration. However, one party's efforts to thwart the other party's right to access to the child may be considered in the court's analysis under Section 152.202A1. This court referenced in re Forlanza, which is also another proposed exhibit that I have with case law. They accepted testimony that more visitation with the children would have occurred in Texas, but for the parents' actions, in fact, that children were not allowed to fly to Texas. In Cortez, the intermediate courts of appeals have held similarly, for example, that the Amarillo Court of Appeals held that the trial court did not err in concluding that the child retained significant connections with Texas when, among other circumstances, the father had exercised or attempted to exercise his visitation rights with the child in Texas on multiple occasions and may have had more contact with the child in Texas but for the actions of the mother. And they were referencing in re LE, which is another case law that I have as a potential exhibit. In re Forlanza, They state, by alleging that the court's prior orders conferred exclusive continuing jurisdiction, the party seeking to modify met the initial statutory burden since the court that makes the initial determination retains exclusive continuing jurisdiction until it determines that the significant connection and substantial evidence requirements are no longer met. The UCCJEA does not premise the exclusive continuing jurisdiction determination on which state has the most significant connection with the child.
I need
And
you to slow down.
Oh, sorry.
The court reporter is trying to keep up. People tend to read
Faster.
faster. Yes. So if you could just slow down just a bit.
Okay. With this case law, essentially, Mr. Solomos has not seen the child. It's been not in person, but he has FaceTime calls with her. He attempts to have FaceTime calls with her. There is evidence of a substantial call log that he's had maintaining connection with the child as best that he can. In the divorce decree, it essentially states that he needs to have 4 supervised visitations, and then he's going to work his way up to like a standard possession order. We're at this phase, which is why we're here for a modification, especially needing temporary orders, where we can't get past the step 1 of the supervised visitation due to reasons within this case. So because he hasn't been able to move past that step 1, he hasn't been able to then move forward to the standard possession order, in which if he had been able to, he would have had visitations with her in Texas. And so our case law, where but for actions of the mother, but for issues within the decree, he hasn't been able to have her here in Texas, but that's not the only consideration the court should consider. He has been having substantial contact with her through FaceTime, voice calls, and then, but for these issues, he would have had more contact with her in Texas. This court has already established jurisdiction. They've allowed the geographical restriction to be Travis County plus Massachusetts. Just because she's moved to Massachusetts should not be a basis to now Texas no longer having jurisdiction, especially since there is this issue within the decree that we are trying to modify to get past to allow Mr. Solomos to be able to exercise his.
Buckle up, guys, because today we're diving into a courtroom battle that quickly turns into a fight over one crucial question. Which state should decide this child's future? The mother's attorney argues that both she and the child have built a completely new life in Massachusetts, making Texas the wrong place to continue the case. But the father's attorney immediately pushes back, insisting Texas still has legal authority because the father has never stopped trying to stay involved, with both sides citing legal precedents and challenging each other's claims. The courtroom is already set for a tense legal showdown.
Visitation with his daughter. Now having to, if the court were to consider transferring to Massachusetts, Massachusetts would then have to look at the Texas decree, figure out how to overcome these issues, and then Mr. Solomos now would have to travel to Massachusetts.
All right. So, counsel, for the purposes of a limit of a special appearance or a plea to the jurisdiction, I think the court is allowed to hear limited evidence only as to the issues presented. Mr. Pockrass, do you have a witness to call as it relates to these motions?
Yeah, yes, Your Honor. I would call Miss Kimberly Buckner.
Okay. All right, Ms. Buckner, if you would unmute yourself. Please raise your right hand and be sworn. Do you swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Good morning, Miss Buckner. Just for the sake of the record, you are the mother of the child in this case.
Yes.
And Mr. David Solomos is the father in the case?
Yes.
Okay. When did you move to Massachusetts?
I initially was only able to pack one suitcase, and it was more of a fleeing situation on January 25 of 2023. And then I officially moved to Massachusetts and got all of my belongings, or most of my belongings, from Austin in March of 2023. And we've been here ever since.
Thank you. And when did you file for divorce?
I filed in May of 2023.
Now, there's been some discussion of Mr. Solomos not being able to exercise visitation. And can you explain to me the step one of the possession order that was granted in your divorce in 2024?
Yes, step one was designed so that David needed to complete 4 supervised visits in Massachusetts before going to the next step up, which was 4 unsupervised visits with no overnights. And I think that was supposed to be completed before September of 2025 or 2024, I believe.
And how many of those supervised visits occurred?
So before the final divorce decree happened, he had a visit so the guardian ad litem could do her report, and that was in April of 2024. And it was 4 hours on Saturday, 4 hours on Sunday. And then after that, after the final divorce decree, he had another supervised visit on June 15th of 2024 using the same supervisor, Eric Rollins.
So that's a total of 3 supervised visitations.
Mhm.
Okay. And what happened on that at the end of that 3rd supervised visitation?
So
The courtroom shifts from legal arguments to first-hand testimony as the mother takes a stand. She explains when and why she moved to Massachusetts, describing it as a sudden escape from an unsafe situation. She then outlines the court-ordered visitation process, revealing that the father completed only part of the required supervised visits. As her attorney carefully builds the timeline, the questions lead toward a critical incident that allegedly changed everything, while the father's attorney begins objecting, signaling that the most disputed part of the case is about to unfold.
given that we had used the supervisor.
Objection, Your Honor. Is this relevant to the plea to the jurisdiction, or is this more of the temporary orders argument?
All right, Mr. Procris, what's your response to the objection? I think the
Sure.
objection is relevance.
So I mean, I believe it's relevant because it's getting to the point as to the argument was made that he hasn't had supervised visitations, but I believe that but for the behavior or the actions of Miss Buckner. And I believe that the line of questioning I'm going down will establish why the so-called alleged actions of Miss Buckner would be in question.
Okay, I'll overrule the objection. You may answer.
At the end of the visit on June 15th in 2024, I had an active protective order granted by the state of Texas due to an incident of domestic violence. And we had protocols set up with the supervised visit so that when I dropped our daughter off, David would be gone so that he was away, the distance needed to be away from me. And the supervisor would stay with our daughter while I left, and then David would come and have his supervised visits. When I went to pick up my daughter, I was running a few minutes late, but I gave the supervisor 3 warnings, text messages, and 2 text messages with our exact ETA, as well as a phone call 2 minutes away. When I arrived to pick up my daughter, the door was wide open. My daughter was standing right there, and I got out of the car to say hi and pick her up. And the supervisor didn't say anything, didn't warn me, but David was in the bathroom and came out and confronted me, and the protective order was violated. And I basically just got back into my car and waited for David to leave. which he did. And then when I got out of the car, I asked Eric, I said, why did that just happen? I have given you a hard copy of the protective order. We have these protocols in place. Why didn't you warn me, try to stop anything? And then he told me
Objection, Your Honor, hearsay.
Sustain.
Can I continue?
No.
Without telling me anything that another party specifically said to you, you may continue.
Okay.
No, no, that's not the way it works. The
Sorry.
objection was sustained, so you need to ask a new question.
Of course, Your Honor. Okay. So Mr. Rollins was aware of the protective order.
Objection, Your Honor, speculation.
I'll overrule.
I had to interview Eric before these supervised visits, and I handed him a hard copy of the protective order, as well as emailed it to him with the guardian ad litem CC'd on it. So he knew about it and then told me that there wasn't one.
Objection, Your Honor, hearsay.
Sustain.
In the prior two visits, Mr. Rollins had instituted, or you testified that there were procedures in place to make sure that you did not come in contact with Mr. Solomos.
Yes.
Is that? Okay. So has Mr. Solomos asked to have another supervised visit with his child?
Yes.
And what supervisor did he ask to use?
Eric Rollins.
And were you in agreement with the use of Eric Rollins as a supervisor after that incident?
No, I was not in agreement to using him again due to that incident.
And what were the terms of selecting a supervisor for these visits that was granted in your final decree?
Both parties have to agree upon a supervisor or a supervised visit facility.
Okay. And once again, you were not in agreement with using Mr. Rollins.
Correct.
Okay. And did Mr. Solomos request Mr. Rollins for that fourth supervised visit?
Yes.
Okay. And how did you respond?
I said the dates that he proposed to visit were totally fine, but please find a new supervisor to use because I was not in agreement to using Eric or a supervised visit facility. There's one 20 minutes away that he could also use in Hyannis, Massachusetts.
And did he propose any alternatives?
No, he just said, see you in court.
And when did that conversation take place?
It was December of 2025.
And when was the third supervised visitation?
June 15, 2024.
So there was a year and a half between the third supervising and him requesting a fourth.
Yes, he did request one more visit in October of 2020.
The courtroom reaches one of its most emotional moments. The mother describes an incident during a supervised visitation where she says a protective order was violated after unexpectedly encountering the father. As she attempts to explain what happened, repeated hearsay objections interrupt her testimony, creating even more tension. She later explains that this incident is the reason she refused to use the same supervisor again, insisting she supported continued visitation, but only under a different supervisor. Her testimony becomes the centerpiece of the dispute over why the visitation process ultimately stalled.
24, but Massachusetts granted me a restraining order for another year due to the incident that happened on June 15th of 2024 with Eric Rollins. But he ended up canceling that trip because of the restraining order. He said that was the reason he couldn't visit his daughter.
Okay, so as far as the step one of the visitation that was ordered in your final decree, was it successful? Did it take place?
The step one?
Correct.
No, it has not happened yet.
Had Mr. Solomos followed the terms of step one, would you have been willing to comply with moving to step two?
No. He has not proposed any alternative supervisor or facility to use. It
Sure.
hasn't
So
even been a discussion. Sorry.
I apologize. Let me rephrase the question.
Okay.
Had he complied
Oh,
properly with step one, would you have been okay with moving to step two?
oh, yes, yes. I'm totally all for the step up schedule. I'm just not comfortable with that supervisor.
I'll pass to Winter.
All right, Ms. Moore?
Yes. For your residents, I want to make sure I understand. You said you officially moved March of 2023, is that right?
Yeah, yes.
To Massachusetts?
Mm-hmm.
But your divorce decree that was entered on May 6, 2024, you've listed an Austin address?
Yes, that's because during the time I filed for divorce in May of 2023, I hadn't lived in Massachusetts for 6 months then. So Austin was technically still my home for 6 months until I had established residency in Massachusetts for 6 months. I'd only been there 3 months or 4 months.
You did not file a notice of address change to let David Solomos know where you're currently living?
It's my mom, it's my mom's house, so he knows where that
That
is.
wasn't my question. Did you file a notice of address change so he would see the documentation on where you live?
I at the post office, I filed for my mail to be forwarded to Massachusetts. I don't know if that counts as an
With the court in Travis County, did you file a notice of address change documenting your new address?
I'm assuming so because my Massachusetts address was in the final decree and I'm not 100% sure. I don't know. But
Your
it was
Massachusetts
known.
address was not in the final decree. It's an Austin address. Isn't that correct?
It's correct because that's how I had to file for divorce was I didn't have established residency yet until the 6 months. But then I was living in Massachusetts and the temporary orders allowed for me to have residency in Massachusetts or in Austin.
I just want to know if you've ever filed with the court what your current Massachusetts address is so David Solomos knows where you're living.
Yes, I believe so.
Can you tell me when that was filed? Because from my review, I don't see anything that's been filed.
Probably was when I got my driver's license updated in Massachusetts. I don't know the exact dates of that. I don't, he knows I've been at my mom's house, so I don't know.
Okay, so it's fair to say that there's likely no notice filed.
I would have to check with my lawyers. I don't know.
Okay. You've testified that Mr. Solomos had completed 3 of the 4 supervised visits per the decree, isn't that right?
No, he completed 1 supervised visit after the final decree, but he had 2 during the temporary orders that were for the guardian ad litem's report.
Did the decree say when the supervised visits were set to occur?
Yeah, going forward from when the final decree was signed.
But earlier with your attorney, you had testified that he had completed 3 supervised visits, isn't that right?
I would count it as 2 towards the temporary orders and then 1 towards the final decree. But there was no step-up schedule in the temporary orders, so all he did was exercise a supervised visit. There wasn't a step-up schedule established during the temporary orders until after the final decree was signed. Then there was a step-up schedule.
Okay.
So
in the decree, it says that both party must agree to the supervisor, isn't that right?
yes,
You had agreed to using Eric Rollins, at least at some point, isn't that correct?
yes,
Does the decree say that you're allowed to change your agreement once you've agreed to a supervisor?
I think the language there suggests that we need to have both be in agreement before a supervised visit happens. And due to the fact that a protective order was violated, I think that constitutes as good reason for me to not feel comfortable with that supervisor anymore.
But the decree does not say that you need to continue to agree for every visit. Isn't that correct?
I don't know.
You don't know what your decree says?
I do know what it says, and I believe both of us need to be in agreement on it. It's not, we have to keep using the same supervisor every single time. We both have to agree upon it.
Did you ever propose any alternative supervisors to Mr. Solomos?
That is not part of my job. He is a grown man and needs to figure that out for himself. And I have provided to the guardian ad litem multiple visitation facilities nearby. And he has never once proposed an alternative supervisor or supervised visit facility. And the visits that did happen, I fully
Okay, thank you.
complied.
Did you ever file a formal complaint against Eric Rollins?
No, I did. I filed a police report.
Did the police report find him guilty of purposefully,
They
assisting
said-
Mr. Solomos?
The police told me when I was filing the report that they probably, if I wanted to press charges, they would have to arrest Eric
It's
and
hearsay
David.
what the police said to you.
Sustained.
Well, it's in the report.
All right, when there's an objection, I need the witness to stop until another question is asked.
Sorry.
Did Mr. Rollins provide to you 3 reports for his supervised visits with Mr. Solomos?
Yes.
And were those reports dated May 6th, May 7th, May 8th, and June 15th of 2024?
I believe so, but the visit, I don't know if that's the date for the visit or when the date for the report.
Those were when they were documented, isn't that correct?
Yes, then yes.
And the final hearing was May 6th, 2024, isn't that right?
Mm-hmm.
So those 3 visits would have occurred after the hearing, isn't that correct?
I'm confused because the 2 visits that happened in April were before the final decree.
I'm not talking about the April visits. I'm saying Mr. Rollins had provided to you, which you've agreed and testified to, that he provided you with reports dated May 7th, May 8th, and June 15th of 2024.
Those dates are incorrect because Eric got those reports to me in April before the hearing.
So you're saying his reports are not correct?
I'm confused because he was writing the report based on the visits that occurred in April. And I'm pretty sure we had to have those reports before the final hearing so the guardian ad litem could read them and make her judgment call.
Is it possible that he wrote reports in April when he had visits in April?
I'm very confused because I have 3 reports as well, but they were dated for the 2 April visits. I think it was April 7th and April 8th, or either April 8th and April 9th. And then he had one more report for the June 15th incident that I received in October of.
The father's attorney takes control during a firm cross-examination, challenging nearly every major point in the mother's testimony. Questions focus on whether she officially updated her address with the court, whether she truly cooperated with visitation, and whether she had the right to reject the previously agreed supervisor. The discussion grows increasingly intense as both sides debate timelines, official reports, and conflicting details surrounding the supervised visits. By the end of this exchange, both parties have exposed major disagreements that the judge must now weigh carefully.
2024. I have 3 reports from him. but I don't know why you have May dates as the dates on those reports, because nothing happened in May in terms of visits or supervised visits.
Okay. I have no further questions, Your Honor.
Okay. Anything else for this witness, Mr. Pakos?
Just a couple things. Now, Ms. Buckner, you testified that you don't recall filing a formal notice of address change document with the court. Is that correct?
Yeah.
Did you inform Mr. Solomos of your address change?
Yes.
Okay, thank you. Even if you didn't file a formal document?
Yes.
Okay, thank you. Nothing further, Your Honor.
Okay. All right. Any other witnesses to call, Mr. Pakos?
Not at the moment, Your Honor.
Okay. Anything else, Ms. Moore, as far as it relates to the jurisdictional issues?
No, Your Honor.
Okay. Okay. All right. Do we want to... So there's no other evidence you're asking that the court consider as it relates to the special appearance or the jurisdictional issues. And do you wish to provide brief summations of your arguments before we proceed?
I would like to give a brief summation if possible, Your Honor.
That's fine. All right, go ahead.
Yes, Your Honor. I mentioned Texas Family Law Code 152.202, which specifically states that if a child nor the child and one parent have significant connection to Texas and the substantial evidence is no longer available in Texas concerning the child's care, protection, training, and personal relationships. Both elements must be established, and I believe that that is the case here. The child has not lived in Texas for up to 3 years. Mr. Solomos had every opportunity to exercise his visitation to potentially get a visitation in Texas. That did not happen. And clearly, this child is 3.5 years old at this point. She is going to school. She has a whole new life in Massachusetts, as does Miss Buckner. And on top of that, I believe the case in re for Lenza was brought up several times as the controlling standard. CJ continues as long as significant connection exists and substantial evidence is present. I do not think that is the case in this part. Yes, Mr. Solomos lives in Texas. However, he is only one parent and has had the opportunity to exercise his visitations in Massachusetts in order to continue having some form of allowing the child to have some form of connection to the state of Texas, and it's just not happened. I believe there's also precedent generally, at least in the state of Texas, that if a child lives, in a separate county for at least 6 months, that county may have new controlling jurisdiction in this case. And here we're talking about a separate state that Ms. Buckner was perfectly, allowed to move to in the terms of the final decree. And it's been years. This child has a whole new life. Ms. Buckner has an entirely new life in a separate state where it would make much more sense to litigate any form of modification or anything like that.
Okay. All right, Ms. Moore.
Yes, Your Honor. As I mentioned in my opening, in Cortez versus Cortez, it explicitly held that physical presence is not the only significant connection that the court can consider with the child being in Texas. For there to be significant connections within Texas, the divorce decree lays out this step-up provision for Mr. Solomos to exercise visitation. There's also electronic communication in there, which Mr. Solomos maintains his phone calls and FaceTimes with the child. This whole issue hinges on this issue of the supervised visitation, which appears to essentially be possibly one remaining supervised visitation that's been a hangup with Eric Rollins. The divorce decree, it simply stated that the parties must agree to the supervisor. They had agreed. There were no terms that this agreement must be maintained. Ms. Solomos rescinded her agreement for Mr. Rollins. Surrounding this June 15th incident, we don't have Mr. Rollins here to provide his side of the story. It could be a simple misunderstanding. But Ms. Solomos also did not provide any alternatives. There is difficulty finding supervisors in the area to exercise visitation.
Both attorneys deliver their closing arguments, each attempting to convince the judge why the law supports their position. The mother's attorney argues that the child has lived in Massachusetts for years and no longer has meaningful ties to Texas, making a transfer of jurisdiction appropriate. Meanwhile, the father's attorney insists that ongoing phone calls, attempted visitations, and the mother's decisions surrounding supervised visits have unfairly prevented the father from rebuilding his relationship with his daughter. With both legal theories now fully presented, the courtroom waits for the judge's final decision.
A lot of this hinges on the fact that because of this issue, Mr. Solomos is needing to modify the terms to make it to where he can exercise visitation. But like I was saying, the whole issue is that Ms. Solomos rescinded her agreement after agreeing to Mr. Rollins. There's nothing in the divorce decree that says that she can do that they must maintain an agreement. And so because of her actions on rescinding her agreement, this supervised visitation has not been able to occur. Mr. Solomos has not been able to move forward within the step 2 and then ultimately to the standard possession order. The cases I've mentioned, the Cortez case references if there's one party thwarting the other person, that can be taken into consideration. Also, his attempts at exercising visitation.
The courtroom finally reaches its conclusion as the judge delivers the ruling. After reviewing the testimony and applicable law, the court determines that neither the mother nor the child maintains a significant connection to Texas, and that the most relevant evidence now exists in Massachusetts. Based on those findings, the judge grants the request to transfer jurisdiction, bringing this legal dispute in Texas to an end. If you enjoyed this courtroom breakdown, make sure to like the video, subscribe to Custody Truth, and turn on notifications so you never miss another real courtroom case. Thanks for watching, and we'll see you in the next video.
Should also be taken into consideration. Ms. Buckner testified that he tried in October of 2024. He tried in December. She was saying yes to the dates, no to the supervisor, which is why we're now here requesting a modification of these terms to get him to be able to move forward. As such, we're asking that the court retain jurisdiction. They do have continuing exclusive jurisdiction and not transfer the case to Massachusetts and delay Mr. Solomos' ability to see his child any further than already has been.
Okay. All right, Mr. Pockris, anything else to add?
Your Honor, the final decree does say that the supervisor must be chosen by agreement. I believe the argument that there is nothing that says that the agreement must be ongoing. Sure, but there's also nothing in the decree that states that the agreement has to be, that the agreement lasts forever and is ongoing. If there's no longer an agreement on who the supervisor is, then there's no longer an agreement.
Okay. Okay, just give me a moment. I'm gonna look at a couple of things in the family code and the file here, but you can remain. We're gonna remain in the virtual courtroom. I just need to look over a few things. All right, after having heard from both parties and their counsel this morning, and with reference to the jurisdictional issues, neither the child nor Miss Buckner have a significant connection to Texas. and substantial evidence is no longer available in this state concerning the child's care, protection, training, and personal relationships. Quite simply, Ms. Buckner and the child's mother and the child are both residing in Massachusetts. I will grant the plea to the jurisdiction, and I will grant the special appearance. Mr. Pockers, do you have orders prepared on those?
Yes, Your Honor, I believe they've been submitted to the box.
Okay. And Ms. Moore, have you reviewed the form of those orders?
I have not had a chance to review the order.
Okay.
We'd be happy to send them over, Your Honor.
Yes. If you would please send those to Ms. Moore, and Ms. Moore, if you could let the court know if you have any objection to the form of the orders by the end of the day today.
Yes, Your Honor.
Okay, and Ms. Seeger is the person you should communicate with. And then once there's an agreement to form, simply email both orders to Ms. Seeger. Any questions for the court?
No, Your Honor.
No, Your Honor.
Okay. All right. Thank you for your time this